All right, listener, get ready. Because today we are diving into a world that might seem, well, a little dense at first glance.
Yeah, I can see that.
Legal rights.
Ah, yes.
You've brought us some pretty heavy-duty philosophical thinking on the subject from the Stanford Encyclopedia of Philosophy.
It is dense.
And our mission is to break it down, I think,
Yeah.
in a way that even Plato would find, engaging.
That's the goal. And that's where having a philosopher's perspective can be really insightful.
Yeah.
We're going to explore not just what legal rights are, but also the deeper philosophical questions
Hmm.
about their origin, justification, and even their limitations.
I like it.
Yeah.
Okay, so let's just jump right in. The text starts by emphasizing that legal rights by their very nature are creatures of law.
Okay.
What exactly does that mean?
Well, it means that unlike some other types of rights that philosophers talk about, like moral rights, legal rights don't exist in some abstract realm. They're created by and through legal systems. Their validity comes from specific laws, judicial decisions, or actions that the law recognizes as generating rights,
Okay, right.
like signing a contract, for example.
So it's not enough for something to just feel like a right to me, like my right to the best parking spot.
Right.
It has to be anchored in a legal framework.
Exactly. Think of it like a recipe.
Right.
You can have all the ingredients for a cake, but it's not truly a cake until you combine them in a specific way, following the recipe.
I see.
Similarly, all the moral arguments in the world won't make something a legal right unless it's recognized and codified within a legal system.
Okay, that makes sense.
Mhm.
And the text highlights two main mechanisms for how this, I like this baking process happens.
I like that.
Yeah. So on the one hand, you have acts of law, right? Like constitutions, statutes, regulations that explicitly lay out certain rights. A good example is the Fourth Amendment of the U.S. Constitution.
Uh-huh.
It directly mentions a right to privacy against unreasonable searches. Right. But then there's the First Amendment,
Yes.
which protects, freedoms of speech and religion without ever actually using the word right.
Exactly. And that illustrates the second mechanism, legal recognition of actions.
Okay.
So certain actions, like signing a contract or creating a will, generate legal rights even if there's no explicit right mentioned in a specific law.
Right.
The law recognizes the act itself as creating a set of legally enforceable obligations and entitlements.
Okay. So we've got these two paths to legal right creation. But the text then throws in this fascinating wrinkle about legal validity versus legal justification.
Yes, and this is where things get interesting. A right can be legally valid, meaning it's recognized by the courts and it can be enforced, without necessarily being legally justified.
Wait, so a court could say, yes, this is a right and uphold it in a case.
Yeah.
But there might still be debate about whether that right is actually justified based on broader legal principles.
Precisely. It's like, well, you could think of it like a house built on shaky foundations. It might be standing for now, but it's vulnerable. Okay. And the legal system is constantly evolving. Legal scholars and philosophers are constantly arguing about the underlying justifications for different rights, whether those justifications hold up and whether those rights should be reinterpreted or even overturned.
So a legal right isn't this, static thing. It's subject to interpretation, debate, and potentially even revision as our understanding of the law evolves.
Absolutely. And I think a really vivid example of this is the Supreme Court's decision on same-sex marriage.
Mm-hmm.
They didn't just invent a new right out of thin air. They had to connect it to a broader, already recognized right to liberty,
Okay.
arguing that the right to marry is inherent in that broader concept of individual freedom.
So that's a great example of how legal rights can kind of build upon each other
Yeah.
and create this, intricate framework of protections. But then the text throws in, another layer of complexity, I guess.
Another layer.
Horfeld's analysis of rights.
Yes. Horfeld, he's like the Marie Kondo of legal rights.
Okay.
He urges us to tidy up our thinking by recognizing the different forms that rights can take, even if we lump them all together under the single label right.
Okay, I am intrigued. Let's break down these different Hofeldian categories, as the text calls them.
Okay, so he identifies 4 basic building blocks.
Okay.
And the first one is what we call the claim right, probably the one that comes to mind most readily.
Okay.
This is when you're entitled to something and someone else has a corresponding duty to provide it or refrain from interfering with it.
Like my right to not have someone come in and just take my stuff.
Exactly. That would be a violation of your property rights,
Okay.
which are a bundle of claim rights.
Mm-hmm.
You have a claim to possess, use, and dispose of your property, and others have a duty to respect those claims.
Okay, that makes sense. What's the next building block in Hofeld's system?
So next we have what he calls a privilege,
Okay.
sometimes also referred to as a liberty. And this is where you're allowed to do something without any corresponding duty to refrain from doing it. So it's about freedom of action.
So something like walking down a public street.
Yeah.
I'm allowed to do it, and nobody has a duty to, like, stop me.
Precisely. But here's where it gets interesting. Even that seemingly simple act of walking down the street is actually underpinned by a whole web of other legal rights
Uh-huh.
working in the background.
Okay.
Your privilege to use a public space relies on property rights, laws ensuring public safety, and even rights related to freedom of movement.
So it's like rights protecting other rights.
Yeah.
Creating this, like, intricate ecosystem of freedoms. Okay, what are the other two categories?
Okay, so we have power,
Okay.
which is the legal ability to change a legal situation.
Hmm.
It's about having the capacity to alter legal relationships
Okay.
or create new ones.
So things like making a will,
Yes,
transferring property, or even entering into a contract.
exactly. These actions all involve exercising legal powers to modify existing legal arrangements or bring new ones into being.
Okay, so it's not just about what you're entitled to, but also about what you're legally empowered to do. Okay, what's the last one?
And finally, we have immunity. This is essentially a shield that protects you from someone else exercising a power over you.
Okay, the text gives the example of a judge being immune from lawsuits for their rulings.
Right.
That makes sense.
Yeah.
You wouldn't want them to be afraid of making decisions because of potential, like, legal backlash.
Exactly. Immunity ensures that certain roles and functions, like those of judges or diplomats, can operate without undue influence
Okay.
or fear of reprisal.
Okay, so we've got these four building blocks: claim right, privilege, power, and immunity. But I imagine real-life legal rights are probably way more complex than just fitting neatly into one box, right?
Oh, absolutely. In reality, most legal rights are like intricate Lego creations, combining different Hofeldian elements into bundles. So your right to free speech, for example, isn't just one thing. It involves claim rights against censorship, privileges to express yourself, and even immunities against certain types of legal action based on what you say.
So this is why the concept of a right can feel slippery. It's not always the single, clearly defined thing. But now I'm wondering, what makes these bundles of Hofeldian elements rights in the first place? What is their core function or value?
Ah, now you're getting to the heart of the philosophical matter. And this is where things get really fascinating. So there are these two major competing theories about what makes rights rights, and each has its own strengths and weaknesses.
Okay, let's dive into those philosophical waters.
Yeah.
The text labels them the will theory, sometimes called the choice theory, and the interest theory. So what's the, like, main difference?
Imagine you have a legal right, say the right to own a piece of land.
Okay.
The will theory says that what makes this a right is the control that it gives you. You know, the ability to choose what to do with that land. Build on it, sell it, even just let it sit there.
Just let it be wild.
Yeah, exactly. You're like a mini sovereign over this little domain.
So it's about autonomy, freedom of choice. Having a right means, like, I get to decide how it's used.
Yeah, exactly. It resonates with those very classic liberal values of individual self-determination, right?
Okay, right.
But then we have the interest theory, which takes a different angle.
Okay.
And it argues that rights are fundamentally about protecting and advancing the interests of the right holder.
Which on the surface makes a lot of sense. Like, the right to free speech protects my interest in expressing myself.
Right.
The right to a fair trial protects my interest in not, being unjustly punished. But the text points out that this gets tricky when you start thinking about, say, corporations having rights. What are their interests?
Right. That's one of the challenges for the interest theory.
Yeah.
And it gets even more complicated when you consider historical examples like a husband's legal right to punish his wife under certain legal systems.
Right.
Clearly, protecting that interest doesn't sit well with our modern moral intuitions about equality and fairness.
Not at all. So it seems like both theories have their limitations, right? If we focus too much on individual choice, we might end up protecting rights that harm others or, go against the common good. But if we only focus on interests, we have to, grapple with whose interests matter and which ones deserve legal protection.
Absolutely. It's a philosophical balancing act.
Yeah.
And the text doesn't shy away from presenting even deeper critiques of legal rights as a whole.
Yeah, that's where things got really interesting for me. The text brings up Marx's critique, the idea that rights might actually reinforce existing power structures and inequalities. especially in a capitalist system.
Yeah, this is a crucial point to consider, especially for a philosopher who's interested in the ethical dimensions of law. Marx argued that legal rights, while seemingly empowering, can actually function as tools to maintain the status quo, even if that status quo is unjust.
So instead of liberating us, rights might be trapping us in a system that benefits the powerful.
It's a provocative idea. Think about property rights, for example. On the surface, they seem fair and neutral. You own what you own, right?
Right.
But in a system where wealth and resources are already unequally distributed, strong property rights can actually solidify those inequalities, making it harder for those without property to gain a foothold.
So it's not enough to just ask whether a right exists. We have to ask who benefits from this right, who is excluded or disadvantaged by it, and does it ultimately contribute to a more just and equitable society?
Precisely. The point isn't to dismiss legal rights altogether, but to think critically about their role in society and be aware of their potential to be used for both good and ill.
Okay, my brain is definitely doing some philosophical heavy lifting here. But let's maybe shift gears a bit. The text goes on to discuss how legal rights function in legal reasoning and how they take on different roles depending on the context.
Right. It's not just as simple as saying, this is a right, therefore it prevails. Sometimes rights act as the outcome of a legal process, and other times they serve as reasons within that process.
Can you give me an example of each? I'm having a little trouble, like, wrapping my head around the difference.
Sure. Let's say there's a case involving freedom of speech.
Okay.
The court might weigh various factors, like the potential harm caused by someone's speech versus their right to express themselves. And after considering everything, they might rule that, in this specific instance, the right to free speech prevails.
No.
In that case, the right is the outcome of the legal reasoning process.
So they considered all the relevant factors,
Huh.
including the right, and arrived at a conclusion that's phrased in terms of that right. Okay, that makes sense. But how would a right function as a reason within legal reasoning?
Okay, imagine a different case
Yeah.
where someone is alleging that their privacy rights were violated. The very existence of a recognized right to privacy acts as a reason for the court to scrutinize the actions in question.
So it's like the right itself sets a standard that has to be met, like a burden of proof on the side that's potentially infringing on that right.
Exactly. The court would then have to determine whether the actions in question were justified, whether there were legitimate reasons for the intrusion, and whether the intrusion was proportionate to the goal being pursued. The pre-existing right to privacy acts as a guiding principle throughout that legal reasoning process.
Okay, I'm starting to see the distinction here. Sometimes rights are the end point, the conclusion we reach after weighing all the factors, and other times they're like the starting point, shaping how we approach a legal question and setting the bar for justification.
That's a great way to put it. And it really highlights how legal rights, while rooted in law, are also deeply intertwined with moral and philosophical considerations.
Speaking of moral considerations, the text brings up this fascinating and somewhat paradoxical concept, the idea of rights to do wrong. How can that even be possible? Isn't a right supposed to, like, protect us from wrongdoing?
It's a really thought-provoking idea, and it gets to the heart of the tension between legal rights and moral principles. So remember those Hofeldian categories.
Yeah.
Well, sometimes you might have a claim right, a legal entitlement that allows you to do something that many would consider morally wrong.
Okay. The text gives the example of freedom of speech. I have a right to express offensive or even hateful views, even though those views might be morally reprehensible.
Exactly. It's a classic example of how legal rights don't always perfectly align with our moral intuitions. The law often has to strike a balance between protecting individual freedoms and preventing harm, and sometimes that means allowing people to do things that we might find distasteful or even unethical.
So it's not as simple as saying that all legal rights are inherently good or that having a right automatically justifies any action taken under that right.
Precisely. It's a reminder that legal rights are tools. And like any tool, they can be used for purposes that are both beneficial and harmful. The moral evaluation of a right and of the actions taken under that right is a separate question from its legal validity.
This whole discussion is making me think about the phrase legal right in a whole new light. Like it's not just a label, it's an invitation to a deeper philosophical inquiry.
Exactly. And that inquiry takes us to another crucial question. Just because a right exists in law, does that automatically make it morally right?
I'm sensing a not necessarily coming.
You're right on the mark. The moral justification of legal rights is a very complex and often contested issue.
The text gives the example of a predatory landlord who, exploits loopholes in tenant laws to evict people unfairly.
Yeah.
They're acting within their legal rights, but it sure doesn't seem morally right.
Right. That's a perfect example of how legal and moral judgments can diverge. And it really highlights the need to constantly scrutinize our laws and our legal rights,
Yeah.
making sure that they align with our evolving understanding of justice and fairness.
So we can't just blindly accept legal rights as, inherently good.
Mm.
We have a responsibility to critically evaluate them, to challenge them when necessary, and to make sure they're serving their intended purpose,
Yeah.
protecting individuals and promoting a more just society.
Absolutely. And that critical engagement with legal rights is essential for anyone, but especially for a philosopher who's grappling with those big questions of ethics, justice, and the nature of law itself.
Yeah, this deep dive is really starting to connect the dots between those legal concepts and those deeper philosophical questions. Now, it's making me realize that understanding legal rights isn't just about memorizing definitions. It's about engaging in this constant process of reflection, analysis, and critique.
Well said. And that process of reflection and critique is what keeps the study of legal rights so vital and so endlessly fascinating.
I feel like we've covered so much ground already, from Hofeld's framework to Marx's critique, and even the thorny issue of rights to do wrong. It's a lot to process,
Yeah, for sure.
but also incredibly stimulating.
It's definitely been a deep dive,
Yeah.
both literally and figuratively.
I like that.
And I think we've touched on some key insights that are particularly relevant for a philosopher grappling with the concept of legal rights.
For sure. I'm starting to see how legal rights are not just these abstract things floating out there,
Yeah.
but are deeply intertwined with broader philosophical questions
Hmm.
about morality, justice, the nature of law itself.
Absolutely. And to kind of help solidify that connection, I think it'd be useful to highlight some features that are particularly salient to legal rights,
Okay.
setting them apart from more general philosophical notions of rights.
Okay, so let's zoom in on those distinctive features. What makes legal rights unique?
Well, one key aspect is their institutional nature. Legal rights aren't just moral principles floating in the ether. They are embedded in a complex system of laws, courts, enforcement mechanisms.
Right.
They exist within a structured framework designed to define, adjudicate, and uphold those rights.
So even if everyone agrees that something is morally wrong, it might not be legally actionable unless there's a specific law against it.
Yeah.
And even then, there has to be a way to enforce that law,
Yeah.
to hold violators accountable.
Precisely. The legal system provides this structured and systematic way of dealing with rights violations, a process for determining when a right has been infringed upon and what remedies are available. It's like having a referee on the field, making sure everyone plays by the rules and that there are consequences for those who break them.
I like that analogy. It really helps.
Yeah.
But having rules and referees isn't enough.
Right.
The process itself has to be fair.
You're absolutely right. That's where procedural rights come into play.
Okay.
These are rights that govern how we engage with the legal system, ensuring fairness and due process.
Right. The text mentions examples like the right to a fair trial, the right to an attorney, the right to appeal a decision.
Right.
These aren't about specific freedoms or entitlements, but about the processes by which those other rights are protected and adjudicated.
Exactly. Procedural rights are the safeguards
Yeah.
that prevent the system from being abused
Right.
or used to unjustly punish people. They ensure that everyone has a chance to be heard, that evidence is considered fairly, and that decisions are made according to established legal principles.
So it's not enough to just have laws protecting our rights. We also need to have a system that guarantees those laws are applied fairly and consistently. It's about procedural justice as much as substantive justice.
Well said. And this attention to process is really a hallmark of legal systems. It's about creating a framework for resolving disputes and upholding rights in a way that's transparent, accountable, and as impartial as possible.
Yeah, this makes me appreciate how legal rights, unlike some moral rights, are inherently tied to the idea of enforcement. If a right is violated, there should be a way to seek redress, to hold the violator accountable, and potentially obtain a remedy.
Exactly. And that leads us to another important distinction that the text highlights.
Yeah.
The difference between perfect and imperfect rights.
Right, so perfect rights, if I remember correctly, are those that are clearly defined and enforceable. You can go to court and seek a remedy if they're violated. But imperfect rights are, well, a bit more nebulous.
That's right. Imperfect rights might be recognized in principle, even enshrined in declarations or treaties. but there's no clear legal mechanism for enforcing them.
Like the text mentioned things like the right to a healthy environment or the right to development. These are like aspirational goals, important values, but not necessarily things that you can take someone to court over.
Exactly. And because legal systems are primarily concerned with practical application, with what can be concretely adjudicated and enforced, perfect rights tend to take center stage.
Right.
They're the ones with clear legal teeth.
Which makes sense. If a right is violated, but there's no way to seek recourse, it's almost like it doesn't exist in a practical sense, at least within the legal system.
Precisely. And this focus on enforceability is reflected in another concept that the text introduces, remedial rights. These are rights that arise when a primary right has been violated.
So if someone infringes on my property rights by, say, damaging my property, I would have a remedial right to seek compensation for that damage.
Exactly. Legal systems don't just define rights, they also establish mechanisms for what happens when those rights are broken. They provide avenues for seeking recourse, for holding violators accountable, and for, making the victim of a right violation whole again.
It's like this built-in system of checks and balances, ensuring that rights have real power, that they're not just like empty promises on paper.
Exactly, and that's what makes legal rights such a powerful tool for protecting individual freedoms, promoting fairness, and ultimately striving toward a more just and equitable society.
I have to say, listener, this whole deep dive has been incredibly illuminating. We've gone from dry legal definitions to this fascinating exploration of the philosophical foundations of rights, their role in legal reasoning, and all the complexities and challenges that they present.
It's been a real whirlwind tour through the world of legal rights, but I think we've managed to unpack some key insights that are particularly relevant for a philosopher like yourself.
Yeah, we've seen how legal rights are intricately connected to those broader philosophical questions about morality, justice, the nature of law, the very structure of society. It's not just about memorizing definitions. It's about engaging in this constant process of reflection, analysis, and critique.
Absolutely. And on that note, perhaps we can leave our listener with one final thought-provoking question to ponder.
Okay.
If legal rights are, as we've discussed, creatures of law, and law is ultimately a reflection of societal values, what does it say about us? About our collective morality that we have the rights that we do?
Ooh, that's a good one. It's a reminder that the study of legal rights is never truly finished. As society changes, so too do our understandings of what rights we have, who should hold them, and how they should be balanced against other values. And that constant evolution is what makes this topic so vital, so endlessly fascinating, and so worthy of deep philosophical reflection.